You want to say your name and who
Sure,
you are?
yeah, it's Adam H. Sudbury, and I'll go ahead and spell that. Adam, obviously, and then H, and then last name S as in Sierra, U, D as in Delta, B as in Bravo, U, R, Y.
Regarding Mark's case, why wasn't Mark given a jury trial? He was sentenced to, what, 6 months, 5 months in jail, all at the hands of a judge. I thought it was a constitutional right that any crime over a $20 value, you were entitled to a jury trial.
Well, that's actually a really good question, and the answer to that is that there's a very narrow exception that's recognized by the U.S. Supreme Court and by many courts around the country, and that is the contempt power of the court. So basically, what that means is that if you intentionally violate a court order, that judge that wrote the order can act as the trier of fact for your trial on contempt, and also can sentence you up to 6 months in jail. So this case, because Judge Perry was the one that signed these administrative orders that makes it illegal to, or against his order, to do the specific things, handing out the flyers to jurors, he is the one that will make the findings of fact and will ultimately impose the sentence. And in this case, he did 141 days, which there was an incorrect release that said 145 earlier, but it's actually 141 days.
Okay. And what about this order is different than the laws that our legislature already has on the books regarding jury tampering? It's already a crime to tamper with juries. So if this order is in addition to that, that would imply to me that Mark wasn't jury tampering, he was doing something else.
Right, and that's been one of the grounds that we raised in our appeal of this conviction, was that in fact there already is a third-degree felony on the books called jury tampering, passed by the state legislature, enacted into law by the governor, and it's already illegal to tamper with the jury. So why do you need an administrative order that says basically the same thing as the jury tampering statute? And what we discovered through that process is it's our belief that Judge Perry is attempting to expand the scope of jury tampering to include really influencing any juror in any way that might serve on a jury. And the problem with that is that the Constitution restricts what can even be ordered as a part of an administrative order. And there's case law on this, and unfortunately, because of the constitutional restrictions, it's our position that his order is limited to the same extent as jury tampering. Jury tampering means you have to have the intent to influence a juror on a specific case. And in this case, it's very clear that this wasn't about Casey Anthony. The incident, in fact, happened in July 2011, but it wasn't about her case. This is completely non-specific, and it's just handed out to anyone, and it's not even specifically targeted at jurors. So there is no difference. There's already laws on the books. The police officers in this case specifically testified in court that Mark was not jury tampering, and they testified that he would have been arrested for that if he was.
Are there any other districts within the state of Florida where this order or a similar one applies?
I'm not aware of any other jurisdiction in the state of Florida with a similar administrative order. In fact, the Fifth Circuit, which is mainly Marion County, and specifically in Marion County, they found that FEJA's activities, the chief judge out there found that FEJA's activities were expressly protected by the U.S. Constitution. And so that was one of the things that at the time in 2011, Mark was aware of this determination from Marion County, and he acted on that, basically saying that, look, these orders can't apply to what we're doing, because not only has no one been arrested here for handing out these FEJA flyers, but also other courts in the state of Florida have determined that it can't be prohibited.
Yeah. Some people have cited, I think it's a USC code, I can't remember the exact number, where it makes it a federal crime to deny people their constitutional rights under the color of law.
Okay.
The first one of the orders that Schmidter was arrested on was overturned by an appeals court, as you know.
Correct.
You were there. ruled that it was unconstitutional to prohibit any First Amendment activity. Mark has already served jail time for that order, even if it was only for a few days. Is there any recourse that could be had against Judge Perry for imprisoning or jailing Mark Schmidter under that order?
Sure.
For infringing his rights.
Okay, so let me, I'll address this in a couple of stages. If you just come over here real quick, and if you look at this box over here on the ground, you'll see kind of like it's now very much faded, a faint outline of a box.
Right.
There was an administrative order that essentially prohibited any quote-unquote First Amendment activities from being done, and that's literally the order said, First Amendment activities, from happening outside of that box. So what we're doing here now, me answering your questions, we would be in violation of that order because we're standing outside of that box. However, wisely, we believe the 5th District Court of Appeal found that that was too broad, that you couldn't do this, and so they invalidated that order. And on that basis, part of our appeal was granted. Now, so we won on that ground, and they cannot require us to stand in any specific place to engage in any type of First Amendment activity, which, number one, includes freedom of speech, but also there's a number of other rights: freedom to assemble, establishment of religion, freedom of free expression of religion, and everything like that. So, so that was invalidated, and so we're left with and if you could just remind me what the original question was.
Oh, it was referring to the USC code. Yeah, okay. That made it a federal crime under the color of law to deprive someone of their rights.
Okay, it doesn't make it necessarily a federal crime, although I believe the Department of Justice can in fact pursue that, but any crime has to be pursued by the authorities.
Okay.
Now, Section 1983 United States Code creates a civil cause of action for someone that's been deprived of their constitutional rights under color of law by a state actor under color of law. And except for a specific, what's called a privilege, that would apply here. However, there is a defense to a Section 1983 action for judicial immunity and prosecutorial immunity, and the litigation of privilege applies. So basically anything a judge does that's part of his judicial functions is pretty much absolutely protected, and this is well settled law under, you know, the U.S. courts have ruled. I believe it's pretty much a frivolous pursuit to try to bring a cause of action for damages, as far as monetary relief. What we're doing in federal court is we have filed, number one, a declaratory judgment action challenging, well, we were challenging both orders, but we won on appeal for one of them, so now there's one remaining order that we're continuing to challenge to vindicate his right, not to seek any monetary damages, but we believe that Mark Schmidter, and in fact all the FIJA activists that do this, have the absolute right to engage in this type of speech, and that there is no basis for a judge or a state legislature, for that matter, to infringe on that First Amendment right to make their point of view known.
Thank you, Adam. Thank you for clarifying that, because we got a couple emails or posts on Facebook asking about, like, oh, why can't you go after Perry because of this USC code? And
there is an absolute immunity, and we're not pursuing that because, frankly, I think that would open myself and my client up to sanctions, including attorney's fees and costs being assessed, and we don't want to necessarily do that. I do want to add one thing as far as like the current status of where things are at. Right now, Mark's conviction has been upheld by the 5th District. We are seeking review of that opinion at the Florida Supreme Court, and we have asked the state courts to release him pending further review at the Florida Supreme Court, and then the next stop after that would be the U.S. Supreme Court. Today, that request was denied by the 5th District. We get to ask the Florida Supreme Court to review that, and if they deny it, that opens the door for us to pursue a federal habeas corpus action in the Middle District of Florida. And I think that is really our best shot of having Mark released pending further appeal. And so that's where we're at right now as far as the procedural posture of the case, and truly we appreciate everyone's support. This cause is a very worthy cause. Not only is free speech at issue, but FEJA's mission, jury nullification, although I don't like to call it that, but really the right of a jury to judge both the law under which someone is charged and the facts under which someone is charged is so incredibly important to our system of justice, because the jury is the last obstacle to physically putting hands on someone and depriving them of their liberty. And if you can't get the facts past a jury, you should, and if a law is immoral and unjust, and believe me, there's lots of those laws out there, a jury should be able to say, we're not going to enforce this. Because when the state legislatures and when the U.S. Congress comes to deprive you of your God-given constitutional rights, it's that 6-person or 12-person jury that is the final arbiter of those rights, and they should be able to judge the law as well as the facts. And that's what FEJA is all about. I personally believe in FEJA's mission. Mark believes in FEJA's mission, and of course the issue of freedom of expression is a critical component to all of this.
Thank you for making that point. Now, do you think for the time being Mark is going to remain in jail until, in your opinion or your estimation, Mark's going to remain in jail until such time that the federal appeals court, I know we're going to the state appeals court, we don't have too very high hopes. We on this end of the camera don't have too high hopes for that.
We're doing everything legally possible. For the time being, he stays in jail until we can get a ruling from the Florida Supreme Court as far as whether or not he's going to be released. Once that happens, that opens the door to federal court, and I think our best shot is asking a federal district judge to consider this, set a hearing, and hear us out. And I think we're talking a matter of a couple of weeks to 2 to 3 weeks before getting that type of hearing. And we hope it won't be too long until we're able to be heard, because it is, in the grand scheme of things, 141 days is a long sentence for someone like Mark Schmidter, who's law-abiding citizen, good moral character, and really a freedom fighter. But in the grand scheme of things, and considering the way that courts work, which is a very slow, laborious process, it's a very short sentence. And if he serves most of his sentence before we even get a hearing on this issue, then really he served the sentence, and that would just be a terrible tragedy. So we're hoping for expeditious resolution of all the issues that we're raising right now.
Thank you, Adam. And it's my understanding that one of the things that the judge brought up when sentencing Mark was that he wanted to institute such a stiff penalty to discourage other people, other FEJA activists, from coming out here and distributing literature relating to juries. From your understanding, if you can talk about it, is that common practice that judges will stiffen the penalty against gentleman A in a way of discouraging gentlemen B, C, and D from engaging in activity? Like, shouldn't people be judged and sentenced based on the acts they commit themselves, rather than serving as an example? As an example.
Judge Perry made this statement at sentencing, and he is completely correct. The theories of criminal punishment really that are accepted in the legal community and really built into the process and the substance of the law allows judges to really consider there's three main purposes for sentencing. Number one is punishment, i.e. your personal mental culpability for something that you've done. It's designed to punish. The second is for rehabilitation, i.e. we're going to try to, make you a good, upstanding citizen, so you won't violate the law anymore. And then the third purpose is a deterrence. So judges do lawfully consider the deterrence effect of a punishment. And so if Judge Perry's intent is to prevent others from violating this order, he can use the process of sentencing in one particular case to deter future or other behavior. And so, and he said that was the main reason for the sentence, and it is a legitimate, recognized historical purpose for sentencing.
All right, cool. That's all I had. Do you guys have any more questions for Adam? Any questions for Adam? He's doing such a good job. He's on a roll.
Yeah, could you explain how Mark can go to Seminole County, which he has, and distribute the same exact flyer to the same type of courthouse, and Mark is in the clink for 6 months?
Sure. Well, in Seminole County, they don't have an administrative order prohibiting, to my knowledge, prohibiting that type of activity. And so there's no one in Seminole County that is going to come and, ultimately enforce an order. And so therefore, FIJA activists are pretty much free to do so.
Isn't this unequal, what do they call it, unequal justice? It's got to be administered impartially across the board. So Mark can do this someplace else. He just can't do it in Orange County.
That's correct, because Judge Perry has the authority, the inherent authority to order things at his own courthouse, the Circuit, 9th Judicial Circuit, and the grounds of this courthouse.
The 5th District didn't quite see it.
Well, that's the thing, within the parameters of the Constitution.
Yeah, because he couldn't do this free speech zone. So.
Correct. Well, they said he cannot do the free speech zones, and so therefore we're pretty much...
Yeah, so really Mark's back to where he was in the beginning, where he really, I don't know, I guess he just doesn't like this particular piece of paper as opposed to other pieces of paper which were given out here all the time.
Sure, yeah.
Just unfair.
Well, and that's one of the grounds that we believe this order was improper, because if it was retaliatory to FIJA, and this is, fundamental tenet of First Amendment law, you can't discriminate against unfavorable speech. So you cannot, even if something on its face looks like it's valid, you can't pass a law, enact an order specifically because you don't like this type of speech and discriminate against this type of speech. So if that in fact was the purpose of this particular administrative order that we're continuing to challenge, then it would also be invalid under those grounds, not in addition to all the other reasons that we've raised. And that's the purpose of our declaratory judgment action in federal court. We're gonna do some discovery. We're gonna find out what the behind-the-scenes purpose of that order is.
In your estimation, would me handing out jury flyers to summon jurors, or even, let's say, actual sitting jurors outside of the courthouse grounds, in your estimation, would that be considered jury tampering? The FIJA flyers themselves.
Well, I'm not going to lend a specific legal opinion on that, but what I will say is that the deputies in this court proceeding back in 2011 testified that what Mark was doing did not violate the felony statute of jury tampering. So, and my understanding of federal law, as it states, is jury tampering requires an intent to influence a specific case. And so where you're just generally engaging in the discourse, for example, you read that FIJA flyer, it's all about the role of the jury in our democracy, in our, republic, in our constitutional republic. It's about the role of the jury, and that's a very general subject that, our position is protected by the U.S. Constitution, no matter who it's distributed to. So that's what we're arguing for, and we hope to, to have the issue resolved ultimately in our favor.
Cool.
Adam, are you working for the ACLU? I mean, who's paying for all this? I mean, how many hours have you spent? Do you have a big law firm?
Oh, goodness.
You drive a BMW? Is it?
I am a, for lack of a better term, solo practitioner. I do have a firm. I've got a few people that work for me, but we're not funded by any organization. Mark has paid some money for my services, but at this point, really, I'm doing this without getting paid right now, and there are costs associated as far as like court reporters and that type of thing, but.
And your hours of work.
And my hours.
You put in on
that's true. I've put in. I would have to estimate probably 60 to 80 hours so far, if not more. But really, we're setting up a legal defense fund. It should be up and running by Wednesday. We're hoping to get some contributions in to continue to fund this fight. We're expecting additional expenses even as we go forward, because to get to the U.S. Supreme Court, we've got to retain lawyers that are admitted to practice before the U.S. Supreme Court. And we really hope that once we put out the information that people will contribute, and there'll be guidelines put out as far as what the money's to be used for and how it's to be used for everyone to take a look at.
And people can stay tuned to the We Are Mark Schmidter Facebook page.
Yes, I would highly encourage that. The We Are Mark Schmidter Facebook page, it looks like, you know, has been set up not by my office, but by friends and supporters of Mark Schmidter, and that's a very good, you know, place to continue looking at getting information on this cause. And like the Facebook page, please spread the word. This is an important cause. I think the general trajectory of this country is to deny us as individuals our God-given, constitutionally secured rights, and governments at all levels are encroaching further and further upon those rights. And unless people stand up and take a stand and really fight back when it happens, we're going to lose them. And one day you'll wake up and you'll realize that I can't say what I want to whoever I want. I can't practice the religion that I want to. I can't own a firearm, which is guaranteed by the Second Amendment. And there's going to be many things that the country's just going to change, and we have to take a stand now.
Cool. All right. Thank you, Adam. Sudbury, everybody. No Give him a hand.